Good afternoon, everybody, and welcome to the Five Stone Buildings webinar program. We're sorry for the delayed start this afternoon, but we are experiencing some technical issues in chambers this afternoon. For those of you that are aware, our telephone lines are down, so we have actually no telephone lines at the moment. We're just going to wait for a few minutes to allow everybody to join before we start. Good afternoon, everybody, and welcome to the Five Stone Buildings webinar program. We've just opened the live link, so we're just going to wait for a few minutes to allow everybody to join before we start. Whilst we are waiting for everybody to join, I shall just let you know that we are hosting a Court of Protection half-day seminar at Inner Temple Lecture Theatre on the 7th of November, and details of that half-day conference can be found on our website underneath the events tab. We are just about to commence the webinar, but before we start, I shall just remind you of the house rules. So just to remind you that this webinar is being recorded. If you have any questions throughout this webinar, please put your questions into the Q&A box at the bottom of our screen, and our speaker will try to come to the questions at the end if we have time. If you do not wish to be identified when asking your question, then please tick the anonymous box so that our speakers do not identify you in their response. And I will now hand over to Elis.
Hello, good afternoon, everyone. And thank you very much for joining me for this discussion about forgery in private client and in particular in relation to wills. This is a subject that I was quite keen to speak about. It's a subject I find very interesting. I've done several forgery claims, some of them to trial, and they are always incredibly interesting cases. But because they don't turn on the law in the same sort of way that many cases in other will validity spheres do, such as testamentary capacity or want of knowledge and approval or similar, I don't think they are given the focus that perhaps those other types of claims are in seminars and so on. And very often the first time that anyone will get a claim like this across their desk will be the first time that they will have to piece together the type of evidence that's needed to litigate one of these cases effectively. Fraud in the private client world is really quite different to corporate or commercial fraud, where the focus may be on weaknesses in systems or transaction processes. Probate fraud is about deception. It's about the exploitation of vulnerable individuals, and the protagonists are people who generally don't involve professionals in their affairs. Entering this world, as it were, is to step from the world of Harvey Specter to the world of Agatha Christie. As is the style these days, I have asked an AI image generator to give me an image of a fraudster forging a document, and there he is. I don't know why he looks like a 19th century American oil man, but there we are. So the questions that we need to be asking ourselves are, what should we be on the lookout for? How does one challenge a fraudulent will? I should say, incidentally, at the outset, that when I say fraudulent will there, I am not referring to a will that's been created as a product of fraudulent calumny or undue influence or similar, which have the flavour of fraud in many ways, but are not the product of a directly dishonest concoction of a document in the nature of a forgery. To give you some examples, one of my favourite stories of a probate fraud was of a case. This is coming up for 20 years ago now, but a West Midlands woman, Joyce Sutton, decided that her home was haunted by a ghost, as you do, and that was the ghost of her husband's first wife. And she called on a clairvoyant, a Mr. Williams, to help her with this. Again, as you do. He did, apparently, and therefore she gained a measure of trust in Mr. Williams. And when sometime later her husband himself died, Mr. Williams got in touch with Mrs. Sutton and said that he had been the subject of a spectral visit from her late husband, and that his ghost had said to look in the grandfather clock in the hall for a will. And so they did, and there was a document there, and perhaps not entirely unsurprisingly, that was a document that divided the estate of her husband half and half between her and him. It was, of course, a forgery, and as the judge dryly remarked as he was sentencing Mr. Williams for fraud, I'm sure that you've foreseen that you're going to prison. You don't need to be a clairvoyant to see that. Similarly, and more recently, some of you may recall the case at Central London County Court, where a young widow who was due to receive a relatively modest proportion of her much older husband's estate, said that she'd found a will which gave her the entire estate, hidden in the attic inside a Doritos packet, and denouncing that claim to have it admitted to probate as ridiculous. His Honour Judge Gerald described the will as an obvious forgery. So these are cases where there is often a fairly brazen attempt, often, I think, an opportunistic attempt, and usually, or certainly frequently, not a terribly sophisticated one, to subvert the wishes of a testator in terms of their testamentary wishes, and to the profit of the fraudster themselves. And so what do we, to give you some recent examples there, there was a farmer who was jailed for forging will documents in a 1 million plus fraud in August 2023. The long-running Patel and Patel saga, Girish Patel, who forged his mother's will to get a £40 million share of his family's Malaysian palm oil plantation. This was a case from originally 2017, but the fallout from that case has continued, and Mr. Patel was the subject of a private prosecution by his, I think, nephew, and was then jailed for 5.5 years for forging the will. And then there is the headline from that case that I referred to a moment ago, Davis and Henderson, which is the Doritos package case. It's also there is the disquieting possibility, of course, that this is also the tip of the iceberg for all of the cases that we are aware of. There are probably many others, or at least an undetermined number of others, where the fraud is either completely undetected, or where the suspicion is there, but the evidence necessary to disprove the will isn't sufficiently compelling to justify taking the risk. So, and it's also, as is obvious from Patel and Patel, it is not limited to small estates where someone thinks, oh, well, I may as well give this a go, and it's not going to be worth challenging. Some very high value cases have been the subject of will forgery proceedings. Some of you may recall from a few years back the Nina Wang case. Nina Wang was, at the time of her death, Asia's most richest woman, but she was involved in a very long-running dispute over her late husband's will, which was eventually upheld, having been found by two lower courts to be a forgery. So, and that was a case involving an estate worth, I think, in the order of 200 million. So these are not cases where people put forward wills or fraudulent wills in low value or trifling cases. Sometimes very large sums are at stake. So there's a list there of reported successful and unsuccessful decisions. Supple and Pender was, for quite a number of years, the sole real recent case, but there's been a spate of them in recent years. Patel, that I referred to a moment ago, Ball and Sisson, which I'm going to refer to in greater detail, which was a case in which I represented the claimant, from 2020, Face and Cunningham, also from 2020, a decision of His Honour Judge Hodge, KC, and Rainey and Weller from 2021. An unsuccessful case, by contrast, where forgery was alleged but not made out, was Cooper and Chapman from 2020, where I represented the, sorry, I think I should say 2022, where I represented the successful defendant who did, notwithstanding the allegations of forgery, succeed in getting the will admitted to probate. So, first principles, in many ways, we don't need to dwell in significant detail on the law, because it should stand to reason that if a document is not genuine, the essence of forgery being to advance a document as a genuine document when it is a concoction put forward in order to deceive. So in many ways, we don't need to dwell on the legalities of that in great detail, because they are fairly straightforward. A will which is fraudulent is a genuine document which does not represent the freely expressed wishes of the testator, either because its creation was fraudulent, or because a subsequent valid will has been fraudulently suppressed or destroyed. We don't see that many cases of fraudulent suppression. It's a relatively frequent thing that clients will say that, oh, I'm sure there was a subsequent will, but it's been suppressed or destroyed in some way. That's a very difficult thing to prove, and generally speaking, unless there is some evidence of it, it is unlikely to be successful. I don't think that I've dealt with a case where there has been a fraudulent suppression of a valid will, but as I say, and as it stands to reason, a will which is forged is not a genuine document. Section 9 of the Wills Act, which requires attestation by two witnesses, is intended to be a bar, or at least a safeguard against fraud. And whilst it is generally the case that in a forgery claim you will plead the backups, if you like, of due execution and or want of knowledge and approval as I suppose, a slightly softer alternative to the very stark, this is not a genuine document. Usually, either you've made out the evidence to demonstrate that the document couldn't be genuine, or you haven't, in which case it is unlikely that a judge will then agree that the one of the other grounds of invalidity would be made out nonetheless. So red flags. What happens with a forgery case? In my experience, what will usually be the starting point is that there will have been, usually in the days or weeks following the death of a testator, where there has been a will. Quite frequently there will be a will in place that people know about, that it will be known what the testamentary wishes were thought to be, and then a document will appear, and it will appear in circumstances which, in my experience, at least some of the following are present. They will appear in the hands of people who would not normally be expected to have custody of them. So someone you wouldn't expect to have a will comes forward with one, or says that they found it in an unusual place, i.e. the Doritos bag I referred to earlier. I did a case relatively recently where the widower of the testator, albeit that they'd been long estranged, said, I discovered a will inside a pack of incontinence pads that was in the testator's bedroom. You may well ask why, even if the document was genuine, someone might have decided that those places were reasonable places to put them. I did another case where, whilst it's a slightly different point, the account of how the will came to be executed was that it had been brought to the house inside a car magazine and then signed and attested and put back inside the magazine to take away. I'll come back to that case on a different point, but you will also find quite frequently, I think, unusual behaviour by the person who puts forward the will. For example, they'll often probe before the will is produced. So they'll say something along the lines of, well, do you know if she made a will? What does the will say? Or if they say something like, I think she made a later one, or I believe that there's a will. I believe I've got one. It'll be very vague to begin with, quite a lot of the time, or they'll say, "Oh, I've got a will. Well, can we see it?" And no. Again, in the case I mentioned earlier with the incontinence pads, the defendant was someone who was saying things like, well, I don't know what I'm going to do with these two houses. The key difference being between the genuine will and the forgery being that in the genuine will he received one house, and in the forgery he received two. And it became apparent that the forgery, which transpired a few weeks later, had been drafted by him in pen, and it was clearly nothing like the genuine will. And the reason for all this is very frequently that this is something that's done quite usually opportunistically, often, I think, without really thinking the thing through in any great detail. and certainly not without without properly putting the thing in context in terms of, by definition, generally speaking, these are documents which are created after the death, I would say, and so what often happens is that the date which is put on them doesn't then tally with what actually happened on the relevant date, or doesn't fit with the chronology more broadly. So you also see, because quite frequently, or more often than not, the people who do the drafting are not people who are familiar with wills in general terms and clearly aren't professionally qualified. They will use, either they will be completely handwritten or DIY, or they will be drawn on some slightly unusual internet precedent. In my experience, quite a lot of the will precedents which are out there, if you just do a Google search, are American ones. And so you find that people have used will precedents which would be nothing like the ones that you would usually see in an English will. Another red flag, a testator who'd previously used solicitor draft wills, apparently having drafted DIY will or asked the relevant person to do so, and having that will attested by witnesses who would not be obvious people for the testator to ask to witness the will, and who usually are close friends of the beneficiary or the defendant, the person producing the will. So if a client comes to you and says, I've got, I think there's a will here which is suspicious, both in the way that it's been produced and in the way that it looks as a document, we are then going to have to embark on the task of pulling the strings together, because by definition, what you're likely to be faced with is someone, the beneficiary, the defendant, if you like, saying, here is a document which is a valid will, which has been attested by the testator and which benefits me. And they will usually be aided in that by their two attesting witnesses, who, certainly in the cases that I've been involved with, are prepared to attest to that being the case. There are forgery cases where the witnesses are not available, but clearly those are significantly less compelling as cases. So you are faced with what can be a fairly formidable obstacle, in the sense that you're going to have to demonstrate that at least three people are lying with the aim of advancing a fraudulent document. And so it is going to be necessary to build, probably at least initially, a circumstantial case that demonstrates that the account that they've given of how that will came to be isn't or can't be accurate. It isn't a step to be taken lightly. Forgery allegations, unlike, say, testamentary capacity or want of knowledge and approval, where the allegation can be, this will is invalid, but no one has, strictly speaking, done anything wrong here. An allegation of forgery is overtly an allegation of dishonesty, and really an allegation of criminal conduct, which could carry criminal penalties, and quite frequently does. So it is not an allegation to be made without reasonable proof. And it is certainly not an allegation to be made if family relationships are not to be irretrievably damaged. Clearly, if that's the situation, then, as is so common in probate cases, then there's not an awful lot to be done about that, but it's certainly not something to be done on a whim. The usual disagreeable costs orders and the like await those who make the allegation without sufficient justification. Expert evidence. Clients love handwriting experts. I think it is, as a type of expert evidence goes, one that clients respond to and are really, it makes them all think they're Miss Marple. And understandably so, I think, but it is overstated in terms of its importance for a number of reasons, I would suggest. There is a case, Fuller and Strum, which you may be aware of, which was, I think, another unsuccessful forgery claim, where it was alleged almost that a judge was not entitled to disregard an expert's view that a will was a forgery. Clearly, that's not right. Expert evidence is evidence just like any other, and it's a part of the general picture that the judge builds up. A point that's been made in the chat, which I'll deal with now, is should any claim be put forward if there are reasonable grounds to support it? Obviously, that's a fair point, and I should be clear what I'm saying. I think an allegation of forgery is a much more binary one than the majority of the types of claims that we deal with. Formal invalidity of wills involves value judgments and that famous quote about the point at which twilight becomes darkness. And it's possible to say justifiably that one person may say, well, I think this is on the darkness side, and someone else may say, well, this is on the light side, as it were. With forgery, I would suggest that we're distinguishing not between twilight and darkness, but between midday and midnight, and it is that stark. So it's a different dynamic to the majority of these cases. So handwriting evidence is, they are rarely conclusive. Handwriting experts do not like, generally speaking, giving a particularly definitive conclusion. What they will say is the validity or the genuineness of a signature is not determined by the presence of similarities, but rather the absence of significant differences. And there are plenty of variations in the way that most people sign day to day in any event. It is rare that a handwriting expert will express a view which is significantly beyond that there is a strong possibility that something is or is not genuine. In practical terms, getting a reliable expert opinion is dependent on obtaining a bank of comparison signatures as a control group. That is increasingly difficult these days in an age where most people don't use checks anymore. It is rarer to use wet ink signatures in a number of contexts. It's not very easy a lot of the time to build up sufficient comparison signatures. Ellen Radley, for example, who is, for my money, the best handwriting expert practicing in this field, will ask for, I think, at least 15 comparison signatures from an equivalent date range from the disputed signature. It is very often not easy to get that. And you'll often find that the other side will be saying that that isn't one that should be considered, that isn't one that should be considered, and so on. It's also worth bearing in mind, of course, that if someone doesn't want the document to be analysed, it may be in their interest to try and limit the number of comparison signatures that are available. It is necessary for the original documents to be available for inspection. Often they will not be. It's worth bearing in mind that it's commonly a feature of forgery claims that the original of the document, of the disputed document, is not made available, and excuses will be given as to why the original can't be found for some reason. The reason for that being fairly obvious. It's not possible to analyze a copy in the same way that it would be the original. And importantly, a genuine signature does not necessarily mean a genuine document. In Patel and Patel, for example, the protagonists in that case had formed a habit over many years when they were running their business of pre-signing corporate stationery so that letters could be sent out with signatures on them without having to go to the trouble of signing them there and then. And it was found that the will, the impugned document, had been put together using one of those pre-signed sheets. So the signature itself was genuine, but not in terms of the context. In other words, that it wasn't, it was a signature on a blank piece of paper where a will had then been later filled in and the attesting witnesses had signed it subsequently. But in those circumstances, if the question had been to the expert, is this a genuine signature? The answer would have been, yes, it is, or probably. So it's very important to frame the instructions to the expert correctly. Ask the question, is it necessary to go broader than merely, is this a genuine document? Sorry, is this a genuine signature? For example, are all of the inks on this page the same? Were the various elements of this document put together at the same time, or are some of them younger, as it were, than others? I thought I would take you through Ball and Sisson in a little more detail. This was a case that I did in 2020, or we came to trial in 2020, where I was instructed by Lee Foster at Banner Joint Solicitors. We were successful at trial. I well remember doing the trial in January 2020 and attending for the judgment towards the end of January, little suspecting that shortly over a week later there would be some news from Italy, which meant that I wasn't going to be doing any trials in person anytime soon. But it's a good example of the type of things to look out for in a forgery claim and how to build it up from first principles, or first building blocks, as it were. A little on the background, Dorothy Ball died on the 17th of March 2018. She was survived by her adult children, David and Linda. She made a will on the 17th of November 2015, which appointed David as her sole executor and trustee and bequeathing 88% of her residuary estate to David, the remaining 12% to 3 grandchildren in equal shares. I should note that she had previously divided that 88% between David and Linda, but there had been a falling out shortly before the 2015 will was executed between Dorothy and Linda, which had led her to make that change. Some might argue that the falling out was a little unfair on Linda. It had arisen out of some problems with Linda being Dorothy's DWP appointee, but be that as it may, the result was that Linda was disinherited. It's also worth noting at this stage that prior to the 2015 will, which was drawn by solicitors, Linda had previously drawn up Dorothy's wills on her behalf using, I think, a W.H. Smith will kit. And the 2 previous wills, I think there was one from 2013 and one from 2010, were in substantially similar forms. Following Dorothy's death, Linda produced what she claimed was a later homemade will, dated the 4th of January 2017, which appointed Linda and her husband Kenneth as executors, and again reverted to the split between her and David of the 88%. David's position was, no, you fell out with, Linda fell out with Dorothy in 2015, and they remained estranged until her death. Linda's position was that the relationship had in fact broken down as a result of a campaign of misinformation by David, that she and Dorothy had reconciled shortly before the execution of the 2017 will, which Dorothy had asked Linda to prepare, and effectively that Dorothy had the scales fall from her eyes about the extent of David's deception, and had asked Linda to help her put things right, as it were. David's case was that the 2017 will was a forgery, that Dorothy's signature was not genuine, and that she knew nothing about its creation. Linda's case was that it was genuine. It was prepared by her at Dorothy's request. It was executed by Dorothy at Linda's house on the 4th of January 2017, and it was witnessed by 2 of her friends, Anthony and Tracy Binks. There was a problem, however, as far as Linda was concerned, namely that it couldn't be true. One thing Linda didn't know was that following her falling out with Dorothy even, David had arranged in late 2016 for CCTV cameras to be installed at Dorothy's house. That CCTV footage was checked, and what it showed was that on the 4th of January 2017, Linda had neither visited nor had Dorothy left the house. One of the things that we spent significant time doing before we showed them this footage was ensuring that we had their account of what had happened set out in significant detail. Linda's position was that she'd called round to her mother's house, that she'd picked her up, she'd driven her back to her house. The will had been drawn up already. everything was ready. She signed it. Mr. and Mrs. Binks, who'd called by attested it even. She then drove Dorothy back round to her house, and shortly afterwards she was called by Dorothy to say to thank her for preparing the will on her behalf. So we'd got them to commit to a detailed version of events. We then showed them the CCTV. They had no answer to it. The initial response was to allege that the footage must have been doctored or tampered with in some way. They were told, well, if you want to inspect it, please go ahead. They said, no, we don't want to do that. We think it's for you to prove that the footage is genuine, not the other way around. That was not a submission which found favour with the court. There were other aspects of Linda's evidence which were problematic. She had this journal that she had drafted. It was relatively clear from the way it was drawn up that it was probably not one that had been drawn up at the time, or at the very least that it didn't record an accurate version of events. But in particular, there was an entry at the 31st of March 2017 where she was told by the police, apparently, I was advised, if possible, to get Mum to sort out her wishes for a will through a solicitor. That obviously doesn't make sense if, on her position, there was a will from the 4th of January 2017, which resolved the concerns. She wasn't able to explain that. And that has similarities to a different case that I remember dealing with, where there was, I represented the widow of the deceased who had a property, a farm, which was occupied by his son. And it was apparent during father's final illness that the son was extremely preoccupied with the idea that he needed to ensure that he was going to inherit the farm, which resulted in certain fairly unseemly things like him barging into father's room at the hospital with documents entitled letters of wishes, which he'd drawn up, effectively saying, I should get the farm, and trying to get Dad to sign them and that sort of thing. But when the will apparently then appeared, it predated the letters of wishes, and one might well ask why there would need to be a letter of wishes purportedly giving the purportedly giving the farm to the son if the will had already been in existence. So, and we're back to the AI pictures. This is Miss Marple, apparently. So that brings me on to the fact that the most common way into a forgery claim will be inconsistencies between the date that a will was allegedly executed and the circumstances of its purported execution. So diaries, appointments, other potentially conflicting information that undermines the possibility that the will was made on the date that it was made is usually the starting point, I would suggest. We were assisted in Ball by expert evidence. Ellen Radley gave evidence on our behalf, and remains to this day the most impressive expert witness I've seen give oral evidence. The judge was clearly extremely persuaded by the way that she dealt with the signature. By contrast, the expert witness who appeared for the other side eventually didn't end up being called, because when he had a joint meeting with our expert, he changed his mind and said, I now think what she thinks. That was suboptimal from their point of view. I've put there, always pay out the rope. Forgers, in common with other fraudsters, are good at deflecting, dissembling, setting hairs running. You can easily imagine if we had presented the CCTV evidence in Ball without having first got them to commit to a version of events and confirming on multiple occasions that the date was accurate, that it would be that what you would receive back is, oh, actually, we must be wrong about the date. It must be actually some other date. And much of the impact of that evidence would then be lost, or at the very least muddied. So it's very important to ensure that the account that the defendants are giving has been set out in detail before it's challenged. If the attesting witnesses are available, try to get witness statements from them early, and if possible, independently of each other. It will be a huge red flag if there is any resistance to there being if someone tries to prevent those witnesses from providing witness statements to the other side, as it were. And if you proof them early, it will limit room for manoeuvre by the defendant later. In my view, it is far too late to wait until the witness statements exchange phase of trial directions. And it will prevent too much coordination between the witnesses if you've got a witness statement from them early. We did that in Ball. In many respects, it didn't end up producing anything startling, and they stuck fairly resolutely to the party line in their witness statements, but it probably did mean that they weren't able then to amend their evidence to a more helpful account to the defendant. Obtain handwriting evidence in the right cases, but instruct the right expert. No expert should be offended if you ask for their qualifications. There are some people in the handwriting evidence field whose expertise is at best limited, or graphologists, for example, are not handwriting experts. They are people who apparently can discern people's personality traits from their handwriting. But there are graphologists who purport to be capable of giving expert evidence. They are not the people to be instructing. Be mindful of its limitations. As I say, there are many clients who believe that handwriting expert is will be definitive one way or the other. It usually isn't. Unless it's a particularly clear-cut case, it will just be part of the broader scope of the evidence. And consider carefully what the scope of the instruction should be. That is to say, are we focusing here on whether it's a genuine signature or whether it's a genuine document? And if so, why? A practical point, be realistic with time estimates. Forgery claims are claims where you're going to be directly attacking the account of probably at least 3 witnesses. Unpicking that takes time. It is not something to be doing at a canter, and you will usually find that they're the type of witnesses who are very good at setting hairs running and making things difficult for a cross-examiner. You don't want a judge dividing their attention between a witness and the clock. We've had a couple of questions. One question that I've received is, if fraud in respect of a will is uncovered, for example, by unauthorized access to a computer, would the Immerman principle still apply? In other words, not to use the documents and to return the documents applied to the court for directions. I'm bound to say that I've not come across a situation where the fraud is uncovered by unauthorized access to a computer. In some respects, it's difficult to see how I struggle to see how that would be the way you would discover it. Because generally speaking, what happens is that someone comes forward with a document. Frequently, they will not be shy about saying that they drafted it themselves. It's quite common. Certainly, I would say it's almost a theme of these cases that a son or a daughter or someone else close to the testator will say, oh, they asked me to draft this on their behalf, and so I did, and here it is. So in some respects, discovering that a document on their computer that they drafted isn't in and of itself going to be evidence of the fraud. The question is whether it was genuinely something that the testator was involved in. In terms of what I will say is that metadata is becoming increasingly relevant in these circumstances. In Cooper and Chapman, the case that I mentioned earlier, that was a case where we admitted a draft from an unsigned draft from a computer to probate. And one of the key pieces of evidence was the metadata, which showed that the creation of the document was in keeping with when it was executed. So I would say that Immerman is unlikely to be particularly relevant to cases such as this. What I would say is that if you did discover something that was found by an illicit search, I think the usual principle is that it's best to err on the side of caution in terms of not using those documents to begin with. You would have to think quite carefully about how to deploy them, I would say. A couple of other questions. That I would, I'll whip through a few. There's a few of these on similar points. Does the judge have an obligation to report fraud to the police? No, they don't. And quite commonly, claimants in successful will forgery cases are quite annoyed about that. The judge didn't make a referral in Ball and Sisson, for example. It is common that they do, and it is common that successful will forgery civil claim will be followed up by criminal proceedings, because the police have largely had the hard work done for them, and they can quite easily see that there are good grounds to prosecute. But it isn't invariably. Do I advise getting the police involved at an early stage? No, I don't on the whole. Firstly, if they will get interested, if they're interested at all, they often aren't. Unfortunately, these days they fraud is one of those things which is increasingly low down the list of priorities for many police forces. And also, getting the police involved is not necessarily going to achieve your aim, which is to successfully disprove the will in probate terms. In relation to disclosing evidence, how much detail would you include in the letter before action is an excellent question. What I would say is that in the first instance, what you want to be doing in the letter before action is saying, you'd probably want to write a couple of letters before the full letter before action, saying, can you please explain X? Can you please explain Y? And then in the letter before action, you'd want to be then setting out, well, we understand your position to be A, B, C, D. We don't believe that that can be accurate because X, Y, Z. But as I say, you don't want to be disclosing, I think, too much of your hand at an early stage. It's one of the reasons why litigating these cases has a different feel to litigating other formal invalidity cases. In terms of, I'm also being asked, was the surprise CCTV evidence involved given in the court or before court? And it was provided pre-action. It was a very strange facet of Ball that they basically spent most of the case seemingly ignoring that evidence or refusing to accept that it had any validity. But we told them, well, here's the evidence which we say demonstrates that this can't be accurate. They said, well, we assume you must have doctored it. We offered them the chance to examine it. They didn't take that up. And their things rested until I think about 2 weeks before the trial, when they applied to adjourn the trial, saying, oh, we now think that an examination of the CCTV is critical because clearly if it's genuine, then that significantly undermines our client's case. To which you might respond, no kidding, but yes, it was provided at quite an early stage, but then resolutely ignored by the other side. If a handwriting expert's report was inconclusive and it later transpired that some of the specimen signatures were not genuine and forged, which the expert missed, what would you advise to do? Well, that's a very case-specific situation. I have to say, I don't think I've come across a situation where some of the specimen signatures were forged. You would hope that one of the ways that you would avoid that is by being at least partially in control of the process. In other words, that you were aware of the provenance of all of the signatures that you were putting forward. I don't know how you would get, I suppose, if the other side were putting forward signatures of which some were forged, that might then create that problem. I suppose it demonstrates that as far as a forger is concerned, they have an active interest in ensuring that lines are blurred as much as possible. What would I advise to do? I would have thought in the first instance, questions to the expert. I see, but the question reads, the expert missed it. So I think that would need a bit longer to unpack than I have available at the moment. But it does definitely show the need to be on top of the expert instruction process. Just be aware that handwriting expert evidence takes a very long time in will cases. It is a very clunky procedure, partly because of the need to gather signatures, partly because of exactly this type of problem that people won't agree on what the specimen signature should be, and partly because the court and or the probate registry will not lightly release a will for examination, and they are very difficult about releasing wills. They need undertakings before they'll release it. You have to give it back to them once you've finished. Usually only the expert themselves are entitled to the will. It won't pass via the solicitors, and so on. So make sure that you do it early. Don't leave it till the last minute to try and get a handwriting expert. You will not get it done in time if that is what happens. What was the name of the handwriting expert that you referred to previously? Ellen Radley of the Radley Forensic Document Laboratory. She is a former criminal solicitor who took over her father, Robert Radley's practice. She is very good. Other experts who I think are good in this field include Elizabeth Briggs, and there's a woman at Keith Borer and Associates called Karen Caramiello, who also I've seen good. Has provided good reports. Just to wrap up on the questions, how is it best to plead the cause of action and the particulars of claim? Forgery. This is not a valid will. It is not. It has been, or this is not a genuine will. It has been created by someone other than the testator. It is not genuine. Will you be provided with a copy of the slides notes after the Zoom? Yes, you will. Joe will circulate them afterwards. In Ball, when the opponent tried to get the trial adjourned to examine the evidence, was this allowed? Sorry, I should have said this at the time. Very much not. It was, if an application could ever be dismissed with extreme prejudice, then that was it. By His Honour Judge Malcolm Davis White, KC in Leeds. Can I repeat that last name? Karen Caramiello, Caramiello. Right, I think that is all we have time for. Thank you for all your questions. Thank you for attending. I hope you found it interesting and hopefully also helpful. And thank you for joining me today. I look forward to seeing you again on another seminar soon. But in the meantime, my email address is there. If anyone has any further questions, do feel free to contact me. And thank you very much.
Thank you, Elis. I'll just remind you guys that this recording will be up on our website underneath the webinars tab in about an hour's time. We also have a Court of Protection seminar coming up that we are hosting in November, and the details of that Court of Protection seminar can also be found on our website underneath the events tab. Thank you guys for joining us today. Goodbye.